Welcome back. We're in the middle of a guided tour, so to speak, of the written Constitution, and we're proceeding in textual order. We've already covered the preamble, how we, the people of the United States, ordain and establish the Constitution in an epic act of continental democracy and free speech, the likes of which had never really before been seen in world history, and in an event that really radically changed the course of world history, and that we, the people of the United States, did ordain and establish that Constitution for reasons of national defense, to secure the common defense and thereby preserve and secure the blessings of liberty for that generation of Americans and its posterity. So that was the preamble, and that was the beginning of our guided tour. Then we talked about Article 1, the legislative branch, this kind of new Congress, borrowing the name of the old Congress, but changing its powers and structure quite considerably. The legislative powers vested in Article 1 in this Congress. We talked about the executive power vested in a president, a newfangled president who would be way more than a governor, state governor, but much less dangerous than an English monarch, and that's Article 2 of the Constitution, the executive power vested in a president. And then we talked about, last and I think least among the branches of the federal government, we talked about the judiciary, the judicial power vested in judges by Article 3 of the Constitution. Now, at this point, I hope actually maybe you've noticed two things, or two things have come to your mind. First, the Constitution is actually pretty well organized, sort of preamble, how it's going to be ordained and established, then legislature, executive, judiciary, each in its own separate article, a kind of separation of powers textually, Article 1, Article 2, Article 3. So I hope you notice that the Constitution actually has a rather nice and tidy, cohesive organization. An ordinary farmer 225 years ago could understand the thing, and it is designed to be understood. The Articles of Confederation, the predecessor document, were much more of a jumble, much less well organized, I think. And some of the state constitutions were relatively tidy. Massachusetts Constitution comes to mind. Others were a bit more of a jumble. So one thing you might have noticed is the Constitution is pretty well organized. So I hope the lectures so far have been fairly well organized too, because we're just tracking that textual flow. Now, it's complicated, of course, because you can't really talk about one branch in complete isolation to the others. Let's take the veto power. It's mentioned in Article 1 because it's part of the process by which laws are made, but of course it's a power of the president, and he's front and center in Article 2. Or let's talk about presidential impeachment. Well, it's a limit on presidential power, but the impeachment powers are vested in the legislature, in the House of Representatives, which gets to, in effect, indict a president, charge him, and the Senate, which tries him. And so, too, if a judge is impeached, that's an Article 3 issue because it involves limitations on the judicial power, but it's also an Article 1 issue because the House basically indicts, the Senate tries a thing, and the Senate, when it tries an impeachment, is sitting as a court of sorts. And so that's a kind of judicial power, if you will. So I hope you've noticed it's pretty well organized, but these things kind of fit together, and you can't fully think about one branch of government without thinking about how it checks and balances and interacts with, is blended with, to some extent, other branches of government, even though there's a basic presumptive separation of powers in Article 1, Article 2, Article 3, the three articles, all of which begin with a kind of vesting clause. Legislative power vested generally in a Congress, executive power vested generally in a president, and judicial power vested in courts. So I hope that's one thing you notice. And maybe the second thought that may have come into your mind is like, well, what's left? I mean, we've done how the Constitution is going to be ordained, and we've got the three branches of government, so aren't we done? Not quite. Today we're going to, and in this lecture and in the next one, we're going to talk about Article 4 of the Constitution. And it focuses mainly on relations between the states. Think about a kind of horizontal federalism. Federalism sometimes means the relationship between the state governments and the central government, the federal government. But sometimes it can also refer to, and the things are connected, more horizontal, that first thing is called vertical federalism. The central government kind of above the states to some extent, because when the federal government is acting within its powers, its competence is supreme, the supreme law of the land. We're going to talk about that in more detail in later lectures. That's vertical federalism, the central government kind of above the states. But federalism is also a horizontal concept, the relationship of sister states among themselves. And the vertical and the horizontal are connected. Everything's connected in the Constitution. But Article 4 focuses centrally on the states. We've seen them before. We've glimpsed them before. Of course, powers generally not given to Congress under Article 1 are going to be left to state legislatures. But Article 4 brings states front and center. And not just states, but what about those parts of the United States that aren't states? What about territories, for example? Article 4 is going to focus on that. So it's going to in part tell us how united really are the states horizontally as well as vertical. And it's going to remind us that the United States actually, strictly speaking, encompasses more than states. It, for example, encompasses the national seat, today known as Washington, D.C. That's not a state. It's not represented in the House or the Senate, but it's obviously part of the United States. It's where basically the government of the United States resides. And so too, territories are going to be, and always have been, part of the United States. And Article 4 is going to focus on them front and center. And in this discussion of Article 4, we're going to see really the same great themes that we've been glimpsing throughout our tour. We're going to see the importance of democracy and self-government. Another word for a kind of synonym, really, for democracy at the founding was republicanism. The two were actually very similar, as we're going to talk about in the next lecture. So you're going to see themes of democracy / republicanism, popular sovereignty, popular self-rule. We're going to see the issue of slavery and the companion issue of race emerge yet again, as we've been seeing it throughout. And we saw it even in the question of, like, who is the people? We the people. Well, who counts and who doesn't count? Do free blacks count? Do slaves count? And Article 4 is going to tee that issue up centrally. So democracy, self-government, race and slavery, and the importance of national security and geography and geostrategy will be another thing that we see in Article 4, as we saw that theme in the preamble and in Articles 1, 2, and 3. For example, on geography, recall that the difference between the Supreme Court and the lower federal courts is basically that the lower federal courts are geographically distributed throughout the country, whereas the Supreme Court is going to be in the national capital. And in that difference, actually, you can begin to understand Marbury versus Madison, which says you can't expand the original jurisdiction of the Supreme Court beyond the trial jurisdiction, beyond what the Constitution provides. And one idea is kind of a geographic idea. Certain things are supposed to be tried in the national center, but other things are actually supposed to be tried. They can be heard in lower federal courts, and these lower federal courts are going to be picked, their judges, just like Supreme Court justices, basically, nominated by the President, confirmed by the Senate, but they're going to sit in the hinterlands in the states rather than in the national capital. So these themes of democracy and geography / geostrategy, which we've been seeing, and slavery and race, which we've been seeing in Articles 1, 2, and 3, and in the preamble, are also evident in Article 4. I'm going to come back to this picture, which begins Chapter 7 of America's Constitutional Biography, which is our sort of handbook for this part of the course. Every chapter begins, remember, with a picture, and if you understand the picture, you really understand the deep ideas of the chapter. I'm going to come back to this picture at the end of the next lecture, but just to anticipate a bit, this picture in the beginning of Chapter 7 is from the printer, Benjamin Franklin. It's generally reckoned the first political cartoon maybe ever. Franklin was a very inventive fellow. The bifocals, the Franklin stove, the lightning rod. He could be given credit as having invented the idea of political cartoons, and this is the first one. It's from 1754, way before the American Revolution, and Ben Franklin is urging a kind of union of sorts of the different colonies with the caption, "Join or Die." I'm going to come back to this again at the end of the next lecture, but just to remind you of how the United States begins. It begins as a series of British colonies in North America. And originally, these colonies are settled at different times, populated by different demographic groups. Folks from some parts of England end up more in some parts of the New World, and from other parts of the British Empire and Europe, they end up in other colonies. So they're not all kind of homogeneous demographically. They begin as these widely scattered outposts on the Atlantic seaboard, founded at different times for different purposes, sometimes by business ventures seeking to make a quick buck, others by the British monarchy itself, still others by religious dissenters, and others trying to sort of escape the old world and create a new world self-government as best they can, while professing allegiance to the crown, but the British crown, but trying to preserve as much freedom and self-government as is possible. Well, as these colonies grow and expand, they start to verge on each other. Borders sometimes get shifted around. But the colonies, you need to understand, are legally distinct from each other. They're connected to the British crown, but not really quite to each other. Imagine a kind of wheel with spokes from each colony to the same king in the center, but not much of a rim connecting the colonies to each other. In 1930, for example, just to flash forward, the British Empire, the British Commonwealth, consists of a whole bunch of different entities that they all have the same common crown, but they're not tightly connected to each other. And you've got Kenya and India and Ireland and Canada and New Zealand and Australia, and they all have a common crown, but not much connection to each other. That's America in, say, the 1750s. And there are British North American colonies to the north in Nova Scotia and Halifax, and to the south in the West Indies. And Ben Franklin, in 1754, thinks there should be kind of more connection among the colonies. He himself is a continentalist. He's born in Massachusetts, and he, at a young age, with kind of pennies in his pocket, just a young man setting out to make his fortune. He leaves Massachusetts, goes to New York briefly, but ends up in Philadelphia, where he does find fame and fortune. But he's imagining, continentalist that he is, way before others are, because most other Americans actually don't leave their home colonies. Most people in the 18th century lived and died in a 50-mile radius, and many of them sort of never ventured beyond that. But Franklin does. He's a continentalist, and as early as the 1750s, he's saying we should create more of a union among the colonies. Still in 1750s under the British umbrella, but there should be more connection actually across these different colonies. He proposes there's a meeting, a gathering, a conclave, a congress, if you will. Among some of the different colonies, they meet in Albany, New York in 1754, and Franklin proposes a plan in which the colonies together will regulate intercolonial affairs. There'll be a council, kind of like NATO or the EU, and they'll regulate interstate affairs, and they will and they will regulate Western territory and handle continental defense, and elect a sort of and the king will pick maybe a presiding officer, a governor of all the United Colonies, and this will all be under the supervision of Parliament and the Crown, but the individual colonial legislatures aren't that interested in ceding power to some central council, and Britain doesn't seem so interested either in bringing all these colonies together, because if you bring them together, who knows what will happen when they start talking to each other. Britain isn't so keen on it. The colonial legislatures aren't so keen on it. So this idea goes nowhere in the 1750s. But see, Franklin, the inventor, he's trying to, as it were, reinvent the wheel. He's trying to create a new kind of wheel that won't just have spokes from the center to the different colonies. He's trying to add a rim to the wheel so that the colonies will be more connected to each other. But this wheel, so Franklin is, so to speak, reinventing a wheel, but the wheel goes nowhere in the 1750s, but his ideas become a model for the Articles of Confederation after independence, after 1776. Now, 13 colonies have decided that together they're going to join hands and wage war, a war of continental liberation against the Crown. So they're in this together, and now they need some sort of mechanism to coordinate their military strategy and their defense expenditures and their foreign policy, their treaties vis-a-vis the rest of the world. They're going to need more of a rim. And some of Franklin's ideas that he had floated in the 1750s come to the fore, actually. And one section of the Articles of Confederation, remember, it's not so well organized as a document. Article 4 of the Articles of Confederation actually has some provisions that become, with a little tweaking, and we'll pay attention to some of those tweaks, but some of these provisions of Article 4 of the Articles of Confederation that builds on Franklin's earlier model will become Article 4 of the U.S. Constitution. So here's one idea, that basically people like Franklin should be able to go from one state to another state. Remember, they're no longer colonies. Now they're states. They should be able to go from Massachusetts to New York to Pennsylvania, as Franklin, as a young man, had gone from Massachusetts to New York to Pennsylvania, and not be treated as aliens, not be treated as outsiders. So one idea is that you're entitled as an American to the if you're as an American citizen, to the privileges and immunities of citizenship in other states. So this idea that there should be interstate privileges and immunities of free ingress and egress. You should be able to go from one state to another, in fact, maybe even relocate and move and become a citizen of another state. But even if you're just a visitor, you should be not discriminated against. You should be treated as an insider rather than as an alien. That's the idea. Interstate privileges and immunities of citizenship. You see this in the EU today, for example. You should be able to get a job in another country in the EU, and you shouldn't have to have a passport to travel from one EU nation to the other. Well, that's the idea of Article 4, that free mobility among the states and to treat citizens of one state as insiders in another state. Well, one important change that Article 4 of the Constitution makes is, under the Articles of Confederation, paupers and vagabonds were accepted from this. So if you're poor, a state could basically exclude you at the border. But Article 4 of the Constitution gets rid of that language. So now, in the future, a penniless Ben Franklin leaving Massachusetts to make his fortune in New York or in Pennsylvania can't be excluded, can't be barred at the gate. So that's, I think, a democratic, egalitarian reform. Another thing is that the Constitution is better worded, its Article 4 on privileges and immunities than the Articles of Confederation were. Articles of Confederation were a little bit confused. The Constitution, for example, is going to make clear that when it comes to naturalization of foreigners. People born abroad who come to the United States, individual states shouldn't have that power. The central government should have that power. So it shouldn't be in the authority of any one state to make someone from Europe, for example, an American. That should be decided by the United States rather than the individual states. But a couple of questions. One, who exactly is a citizen? In particular, what about, because there's not quite a definition, a clear definition of who is a citizen. In order to be president, you have to be a citizen of the United States and a member of the House or the Senate, a citizen of the United States. But what does that mean? And in particular, can black people, free black people, not slaves, free black people be citizens? Well, I think the best reading of the Constitution is, yes, they can be if their state, their home state recognizes their citizenship. Free blacks fought at Bunker Hill and in Massachusetts and voted for the Constitution in Massachusetts and several other states at the founding, and were treated completely equally in several of the states. And Article 4 does not use the word white. It could have used that word. Actually, South Carolina wanted it to use that word, but South Carolina got outvoted on that. In the Articles of Confederation, in implementing parts of the Articles of Confederation, sometimes the word actually white was used in certain contexts, but not in efforts, again, to implement the Articles of Confederation, but not in the Constitution. So I think the best reading of Article 4 is it has no race test. And if it had, actually, the people of Massachusetts would have been unhappy with that. They voted down a proposed state constitution in 1778. Because it had some racial qualifications, and the people of Massachusetts in some places didn't like that. They were offended by race tests. That word is purposely omitted from the Constitution. But in the 1850s, the Supreme Court, which is going to be populated by justices picked by presidents picked by an electoral college, which leans toward the South because of the 3/5 clause. This pro-Southern Supreme Court, presided over by Roger Taney, who succeeds John Marshall. Taney is Andrew Jackson's man. He's put on the court. He used to be in Jackson's cabinet. He's put on the court by Andrew Jackson. Taney, in a case called Dred Scott in 1857, is going to say several things. But one of the things he's going to say is free blacks can never be citizens. Even if they were born free in Massachusetts and Massachusetts calls them a citizen, even if they vote in Massachusetts, even if their free-born father voted in Massachusetts, even if their free-born grandfather voted up for the Constitution and fought at Bunker's Hill, Taney says, no matter, free blacks, people descended from Africa, can never be citizens of the United States, never be entitled to the privileges and immunities of citizens of the United States. Now, I think that was a mistaken reading, and it's going to precipitate the Civil War. Lincoln is going to have a strong reaction to other elements of Dred Scott, not so much that one, but other aspects of Dred Scott. And so in our next lecture, we're going to talk a lot more about race and slavery and how it plays out throughout Article 4 and is eventually going to help us understand why the early Constitution, this very well-organized Constitution, ultimately fails in the 1860s. So stay tuned.